Oh, there we go. I can't hear you. There you go.
You complaining? You complaining that you can't hear me?
You're already live?
What I was doing was I was actually putting up some of the comments. So we've got a few people already here. So I was putting up the comments. Millbilly's talking about the phone calls that he's got from between Steve and whoever. Have you had a chance to listen to any of them yet?
No.
I listened to the one between Stephen Avery and Steve Glynn, just as Brendan had, quote unquote, confessed.
Right.
So that was quite interesting.
Hmm.
You know.
I know Travis was finding a couple of them interesting, so
Yeah.
I've been meaning to listen to them. So
Yeah, well, unfortunately, there's only 23 hours in the day, isn't there? You've got to knock off 1 hour for sleep, haven't you, dude?
Yeah, at least one.
Yeah.
Although, but when you're at the point where you're only getting one, if you fall asleep, you're not getting up on time. So it's like you always end up just going, you know what? I got to just stay up that last hour. That's what I end up doing. So that's why I don't ever let that happen. But because I don't know, you know what I mean? You try to go to sleep for just an hour. It's like you never ever wake up in an hour. It's like it's like at least 2 hours, right? And then, anyways, no.
Well, I tell you, the good thing is, as you get older, when you get to as old as me, right?
Right.
Because I'm a good 20 years older than you.
Still 2 hours probably before that happens.
I can just fall asleep, right, for about 10, 15 minutes and wake up, and I do that regularly, Yeah. Anyway, how's it going?
Oh, not bad.
Nah,
good. I'm finally getting the studio in order, so that Mark Hodnott will be happy.
Where's Belgium?
I had to rotate it out. Been discussing that in videos recently that I'm going to probably start a rotation.
Yeah.
So I started with Australia and the Lion Rampant because those are the ones I've gotten most recently.
Yeah.
Belgium got to be up there all by itself for a while, so it seemed only fair that it would be the first one out of the rotation. So.
Yep, and also you've got the banner,
Yes, well, there's also that. I could even rotate that in if I wanted.
Yep. Anyway, just to let you know, it's.
We'll be taking those with us to do the event, by the way, on the 14th.
Good.
At the Queen Mary and at Downtown Disney. So for those who are hoping to be in Southern California for the 14th of December, maybe come join us and be part of that.
Yeah. Happy days.
Yeah.
That was the answer I was looking for.
And that was, I saw. And the GIFs were funny on it because people were like, I don't know, and posting like a shot of Marion saying, and oh man, hilarious.
I think you did one of the phones, didn't you? Talking to somebody.
No, somebody did actually, but it wasn't me. But somebody did. It was funny because he says, "I don't know," right? And he's like,
"Yep." And I've got a few other ones here, so I quite like this one.
Yeah.
You not got that one? No.
Where's Donald? Right. Okay.
Okay. But I think this is my favorite.
Right. No, yeah, I saw. Yeah, you posted those. Saw you posting those.
Anyway, we should be getting back to what we should be
Donald?
Doing. Where's Donald? I like your voice. Can you remember we were up to? I would call it it was the sort of Tom Jones part of when they were talking about it's not unusual. There was nothing unusual about the. What was going on? I think we were about to do. You just done number 59, is that right?
No, we're about to start number 59. Is the way I remember it.
59. Okay, so this is That is this
Oh,
one
very
here.
well. There
There
we
we
go.
go. There we go. 59.
Right.
Okay.
So,
This shouldn't take long because you did the bulk of them.
oh, I'm still reading.
Well, I'm happy to read if you want.
Well, I'll start. I'll
Okay.
start out reading, but I've been having a few beers, so if I start to slur, I'm going to hand it over.
Would we recognise the difference?
Oh yeah. Okay. Anyways,
Stella.
number 59. In its reply to Attorney Kratz's untimely objection to costs, the OLR informs us that it chose not to accept the terms stated in Attorney Kratz's email. The OLR states that it did not agree to Attorney Kratz's suggestion that the time he allegedly refrained from practicing law should be credited against any imposed suspension. The OLR did not agree to starting the suspension period less than 3 weeks after the date of the email, and the OLR further informs us that it reminded Attorney Kratz that the court prohibits parties in OLR cases from engaging in plea bargaining. Finally, the OLR tells us that at the time of Attorney Kratz's email, the OLR director reconsidered the viability of each misconduct count and determined it would be inappropriate to drop the count suggested by Attorney Kratz. We declined to equate Attorney Kratz's highly optimistic settlement offer with an extraordinary circumstance sufficient to justify a reduction in costs. Although we have long allowed lawyers and the OLR to enter into stipulations of fact and law and jointly request the imposition of a justifiable level of discipline, we refuse Attorney Kratz's invitation to undertake the task of evaluating the parties' efforts to reach a stipulation, i.e., to review the history of the parties' case discussions in order to determine who was willing to stipulate to what, when, and at what consequence, whether a stipulated outcome was reasonably achievable, and how much the SCR cost totaled at the relevant point in time. Complicated stuff.
It is, yes.
When you're talking about Kratz, though, that's what he does.
Yeah,
he does everything he can to complicate it and make it more, just to make it all that much more difficult to deal with, and like that's part of his strategy.
Yes,
is that in itself. So
absolutely.
All right. This is not to say that it is impossible for an attorney to limit or even eliminate the imposition of costs under the SCR. An attorney may entirely avoid paying the cost of a proceeding by entering into a comprehensive court-approved stipulation prior to the appointment of a referee.
Shall we see what's on the next page? There we go.
This is not to say that it is impossible for an attorney to limit or even eliminate the imposition of costs under SCR. An attorney may entirely avoid paying the costs of the proceedings by entering into a comprehensive court-approved stipulation prior to the appointment of a referee. In RE discipline proceedings against Compton.
Yeah.
This was not done here. After the appointment of a referee, an attorney may stop the running of SCR costs by entering into a stipulation that eliminates the need for further litigation. This was not done here. What was done here, according to the record, is that Attorney Kratz emailed a stipulation proposal written in self-interested terms, and the OLR rejected it. This is not an exceptional circumstance. To modify a familiar refrain, you can't always get what you want or what you need. Damn.
Who was it sang that? You can't always get what.
That's the Rolling Stones.
I was gonna say, I thought that was the Strolling Bones.
But it's you can't always get what you want, but you get what you need. And in this case, that's hilarious. Or what you need. Damn. That's cold. All right.
Sorry, I have to do that first line there. We do not find.
Okay. We do not find costs incurred extraordinary either. The cost consists of about $15,000 in fees and disbursements from the OLR's counsel, about $5,700 in the referee's fees and mileage expenses, and about $2,900 in court reporting and other costs. Attorney Kratz does not argue that these costs were in any way inflated. He does not challenge the billable rates of the OLR's counsel or the referee, or the time spent by either on any particular task. He does not challenge any disbursements or expenses or excessively high. He does not do what the SCR instructs, explain with specificity the reasons for the objection to costs, and state what he considers to be a reasonable amount of costs.
I like,
Basically, stating it clearly isn't in his wheelhouse.
yeah.
Okay, in the place of specificity, Attorney Kratz resorts to hyperbole. He writes in his tardy objection to costs, as this court should know by now have undeniably as this court should by now have undeniably determined there is nothing ordinary about this disciplinary case brought by the OLR against the respondent. The assessment of any costs against the respondent as a result of the OLR's insistence on a formal hearing is unjust and borders on where'd it go?
I think it goes to the top of that one.
Yeah, wait. Borders on. Oh, yes. The intellectually insulting. It was the respondent himself who has done everything since well before any formal grievance was filed with the OLR to resolve this entire matter with professional humility, having immediately and consistently taken full responsibility for any possible Supreme Court rule violation. Full responsibility, you say?
Yeah, yeah.
I recall a fight he had with what was his name again?
Foley?
Foley, Ryan Foley, wasn't it?
The reporter.
Yes.
Yeah.
And he's like, he didn't sound like he was taking any kind of responsibility. He just kept getting more and more complex in his argument.
Yeah. Yeah.
All right. The record proves otherwise. In every stage of these proceedings, Attorney Kratz has employed a tooth-and-nail litigation approach. He denied all misconduct in his answer to the OLR's complaint and raised various constitutional, jurisdictional, and procedural defenses. He accused the OLR of operating under a conflict of interest of an interest and of unethically leaking information. He moved to dismiss the OLR's complaint on 9 separate grounds. The referee later rejected the motion as replete with bare assertions of fact, which were not properly before the referee and may not be considered. He engaged in vigorous discovery practice, including propounding over 125 interrogations.
Fourth line down.
Yeah. Filing discovery motions and attempting to compel the production of documents from the third parties. He raised arguments that ranged from the incredible, disputing his text messages to SVG contained sexual overtones, to the hyper-technical, claiming the OLR complaint was barred by the civil doctrines of issue and claim preclusion because an OLR investigator initially declined to forward SVG's grievance for formal investigation.
Inconsistent.
To the inconsistent, denying any recollection of making inappropriate comments to the SS by claiming credit for having recognized their inappropriateness and apologized. To the puzzling, arguing that he could not have told RH that a reporter had big, beautiful breasts because the reporter in question was not beautiful and was not large-breasted.
I mean, I think as you quite rightly pointed out, he tries to show off that he's this somehow super brain, that he's more intelligent than the rest of them.
Right.
By coming up with these, as the OLR has just explained there, and the referee has explained there. You're nothing special. Your arguments are complete nonsense at times, aren't they?
Yeah.
Let's see if I've got 66 from the beginning. Yes, there you go.
Okay. It was, of course, Attorney Kratz's right to vigorously contest the misconduct charges. But SCR makes clear that when a lawyer whom this court ultimately finds guilty of misconduct imposes costs on the disciplinary system, he or she must expect to pay. And litigation, as every litigant knows, is not cheap. We refuse to transfer the litigation costs that Attorney Kratz has generated to the other attorneys of the state who are innocent of any wrongdoing.
I mean, that's the point, isn't it? Well, if he doesn't pay the costs, who does?
The attorneys other attorneys.
attorneys.
The attorneys that worked on this basically eat the time they put in on it.
Yeah.
You know, because Kratz decides that his, it's just the level of what he feels he can do and get away with. I mean, that's what he shows, and it's just like unbelievable.
Because that's what he had been doing. Anyway.
Yeah. And how is that happening? There must be a culture there that allows that kind of thing to kind of flourish and really take root.
Afraid so.
In the end, there is nothing extraordinary here from a cost perspective. Our general rule is to impose full costs upon the finding of misconduct, and we do. So here. It is ordered that the license of Kenneth R. Kratz to practice law in Wisconsin is suspended for the period of 4 months, effective July 11th, 2014. It is further ordered that Kenneth R. Kratz shall comply with the provisions of SCR 2226 concerning the duties of a person whose license to practice law in Wisconsin has been suspended. It is further ordered that within 60 days of the date of this order, that Kenneth Kratz shall pay to the Office of Lawyer Regulation the costs of his proceeding. It is further ordered that compliance with all conditions of this order all conditions of this order is required for reinstatement. I join the the per curiam opinion.
Yeah, so this is now
Shirley Abrahamson.
She's now retired, isn't she? Just recently retired. Is that not how there was that Brian Hagedorn took over?
Could be. So she is concurring with the first one.
Yep.
So the OLR disciplinary system is about 15 years old. Several anomalies and proposed amendments have been brought to the court's attention. It is time for the court to institute a review of the system rather than to make piecemeal adjustments at this time. See my writings in that, whatever, okay. I welcome Justice Prosser's support for an impartial, objective, thorough review of OLR practices and procedures, support he gave at the Open Rules Petition Conference in October of 2013. For a history of a proposal for such a review, listen to the Open Rules Petition Conference of October 25th, 2013, in connection with proposals for change in OLR's practices. The questions of instituting such a review will come before the court again. I hope it will get 4 votes.
Then this is another judge.
Right. David Prosser, concurring in part, dissenting in part. From time to time, every government agency would benefit from an impartial, objective review of the agency's practices and procedures. There is increasing evidence of the need for such an evaluation of the Office of Lawyer Regulation. This case highlights some of the problems facing the agency and why an objective review would be desirable. Like, somebody, they're like, what? The OLR did something wrong here? Like, what? Okay, anyways, it must be stated that at the outset that the misconduct of Attorney Kenneth Kratz requires discipline. I concur in the recommendation of the referee that Attorney Kratz receive a 4-month suspension, which is the suspension approved by the court. OLR wanted a 6-month suspension. A 6-month suspension would require Attorney Kratz to seek readmission from this court, a process that often takes the better part of a year. A suspension of that duration would have been unreasonable. Oh, poor Kratz.
Yeah,
poor Kratz.
I know.
You know, folks. This is how Len Kaczynski can harass a clerk. He can come into the offices when he's already been told to stay away with a little cat toy and meow at that clerk for 45 minutes. He can eventually get convicted by a jury for harassing that clerk and then violating a restraining order. And then, no time served. Here you go, buddy. Get back to work.
Mm-hmm.
I mean, this is just, yeah. Anyway, so The OLR, yeah, So
79. 79?
OLR also asked that Attorney Kratz pay all costs of the proceeding, namely $23,904.10, and the court approves these costs contrary to the recommendation of the referee. The exorbitant amount, the exorbitant costs requested by OLR and granted by this court require discussion and prompt this partial dissent. So OLR charged Attorney Kratz with 11 counts of misconduct. The first 4 counts involved SVG. One of these counts was later dismissed by the OLR. The counts involving SVG are the reason why Attorney Kratz requires discipline. They are described in the 722 of the per curiam opinion. Attorney Kratz's conduct was highly inappropriate and cannot be defended. What is important for this concurrence dissent, however, is that the substance of these counts, including all text messages between Attorney Kratz and SVG, were self-reported by Kratz to OLR on December 4 of 2009, making proof of ethical violations easy to accomplish. Thus, one of the first issues to examine is why OLR did not file any charges against Attorney Kratz until November 30th.
Isn't that an interesting thing? Because although the OLR is obviously they are taking punishment, handing out punishment to Ken Kratz, they themselves were received quite a lot of criticism for not having handled it sooner.
Well, if he self-reports in December, but they filed charges in November. Anyway.
Yeah, but it's nearly a year later, isn't it? That's December
2011. That's okay.
This is now,
that is. That's 2 years later. Okay, that's 2 years later.
Yep.
So that is. Yeah, it's like that whole thing with Ryan Foley. Let the cat back out of the bag, and the OLR decided they had to do something. It seems obvious in retrospect that Attorney Kratz suffered a serious breakdown of some sort by October of 2009. He had been through considerable stress from 2005 through 2009 as special prosecutor in the high-profile murder trials of Stephen Avery and Brendan Dassey in Manitowoc County. Post-conviction proceedings in Dassey's case were still pending in the fall of 2009, culminating in a 5-day hearing in 2010. Attorney Kratz and his then-wife separated in October 2009 during this stressful period, and he began to abuse prescription drugs. Whether these stresses and difficulties contributed to Attorney Kratz's October conduct is speculative, but the stresses and difficulties are not speculative. Yeah. Anyway.
Yeah.
Counts 1, 3, 4, 5, 6 are based on incidents that occurred during October 2009. No date is given for the incident in count 7. Attorney Kratz's unacceptable text messages with respect to SVG took place over a period of 3 days in October of 2009, approximately a week after separation from his wife. On the 3rd day, SVG took the matter to local police. Within 2 weeks, Kratz had removed himself from the criminal case in which SVG was the victim. After the Wisconsin Department of Justice was notified of Attorney Kratz's conduct, it pressured Attorney Kratz to resign as the chair of the Wisconsin Victims' Rights Board and to self-report his misconduct to OLR. He did the latter on December 4th of 2009, admitting his misconduct and expressing his embarrassment for it. When OLR received Attorney Kratz's communication, including all the text messages, it recommended an investigation. Thereafter, and on February 4th of 2010, OLR received a grievance from SVG on February 18th, and OLR investigator wrote to SVG asking that she contact the investigator. On March 5th, having received no response from SVG, the investigator notified SVG that the matter had been closed. Attorney Kratz was notified of this action. In sum, 3 months after it received all the information necessary to prosecute Attorney Kratz, and barely a month after receiving the grievance from SVG, OLR closed the case. The record does not indicate why SPG did not follow up on her grievance. The record does not indicate why OLR closed the matter when it had ample evidence to proceed if it wished to do so. OLR's letter to SPG stated that Attorney Kratch's conduct did not appear to involve possible professional conduct. 6 months later, Kevin Sellon, director of the OLR, was contacted by Ryan Foley. Is it going to be? Yes. A reporter for the Associated Press. Sellon later indicated in an affidavit that he had not been aware of the Kratz matter before the Foley inquiry. The following day, September 15, 2010, Foley wrote a news story based on the information he obtained from a police report released by the Kaukauna Police Department. Foley did not reveal how he learned about the police report describing Attorney Kratch's conduct. Foley's AP story triggered a political firestorm less than 2 months before the 2010 general election. There were immediate calls for Attorney Kratch's resignation as Calumet County District Attorney. When Attorney Kratch did not resign, Governor James Doyle initiated proceedings to remove him from office. The Kratz matter became a political issue. Scott Hassett, the Democratic candidate for Attorney General, accused his opponent, incumbent Attorney General J.B. Van Hollen, of knowing about the Kratz matter for nearly a year and doing nothing about it. Democratic Party Chair Mike Tate accused Van Hollen of a cover-up after discovering the sexually harassing text messages fellow Republican and political ally Ken Kratz sent to a woman whose boyfriend he was trying for nearly strangling her to death.
If we go to the Convoluted Mind site, you can actually get that opinion by Van Hassett, Scott Hassett, which is very interesting, you know?
Yeah.
Sorry.
Okay. Attorney General Van Hollen responded to these attacks with assertions that the DOJ pressured Kratz to resign from the Crime Victims' Rights Board and advised him to self-report his conduct to OLR. There are no bones about the fact that the Office of Lawyer Regulation dropped the ball here. Van Hollen told the Post-Crescent newspaper in Appleton. He said he was surprised to learn that OLR had told SVG that Attorney Kratch's conduct did not appear to involve possible professional misconduct. I personally am very concerned with the fact that the Office of Lawyer Regulation determined that there was nothing wrong with this activity, he added. I'm not so surprised, really. Yeah. Look at what the punishment was. Only 4 months, because if they did 6 months, oh man, that would end up being a year before Kratz could get his license to practice law reinstated. Yeah. Oh, that is just terrible. You wouldn't want to actually punish the bastard for violating, the trust of a victim of a horrific crime of her boyfriend trying to strangle her. Mm-hmm. And it's just like, oh, good Lord. Anyway.
But you see, the thing is, I mean, there's no dubiety about the fact that Ken Kratz did all this. What I find interesting is this cover-up by the OLR, by the Wisconsin, basically by the.
Why are they okay about it?
Does it not strike you a peg Lautenschlager?
It's only 4 months. Yeah, it's only 4 months. And why the hell do they care about the inconvenience it's going to be to the guy, to the perpetrator, essentially? Mm-hmm. It's like, I don't know. That's the problem with me. Mm-hmm. If it's not a lawyer or whatever, somebody they like or whatever, play ball with, then they would throw the book at him. But because he's the right person or of the right, walk of life, that he is like subject to a different set of rules. Mm-hmm.
But remember that in one of his emails, Kratz actually wrote to the DOJ that that basically he has given unquestionable support to Van Hollen, and that included obviously the financial support. Mm-hmm. For his right. Campaign, so there does seem to be quite a political issue going on here, doesn't there?
Let's see.
Have we skipped one? No,
I think so. There we go.
Yes.
From all appearances, the OLR determined to make up for dropping the ball. It selected as outside counsel Thomas Basting, who filed 11 charges against Attorney Kratz, including 7 counts related to 4 new matters.
Yeah, so I think I think we skipped a bit there because where did we get to? Yeah, and personally, I'm very concerned with the fact that I've sort of determined that there was. I think we got to 92, hadn't we?
I was just reading 93. We need to get to the rest of 93.
But we hadn't actually covered 92 yet.
The OLR, having received the letter from SVG's attorney Michael Fox, reopened the Kratz investigation. Additional complaints came in. More than 13 months later, OLR filed its complaint.
There you go. Yep.
Okay.
And then,
from all appearances, OLR was determined to make up for dropping the ball. It selected as outside counsel Thomas Basting, who filed 11 charges against Attorney Kratz, including 7 counts related to 4 new matters. In one of these charges, OLR essentially accused Attorney Kratz of sexual assault.
Mm-hmm.
After various phone conversations, Kratz asked to visit JW at her apartment. JW asserts that Kratz arrived at her apartment and after threatening JW, forced her to have sex. On September 28th of 2010, JW provided the information about Kratz to her probation officer at the Department of Corrections. The DOC reported the issue to the DOJ. The DOJ interviewed JW, who provided a statement. The statement JW provided alleges that Kratz, while District Attorney of Calumet County, had forcible sex with an emotionally vulnerable woman after previously prosecuting the woman.
Obviously, that was one of the worst of the cases because he was threatening that he could make her life really difficult.
Right.
He could really jam things up for her.
Right. Looking backward, OLR. Let's see.
Sorry, 94.
No. In filing this sensational charge pertaining to alleged sexual assault, OLR not only discredited Attorney Kratz, but also implicitly criticized the DOJ and local law enforcement authorities for failing to prosecute him. It later quietly dismissed the charge. As noted above, OLR also asked that Attorney Kratz be suspended from the practice of law for 6 months.
Yeah, the main problem with that complaint, the one that ultimately dropped, was the fact that I think the woman had got previous convictions and was actually incarcerated at the time when the DOJ got round to speaking with her. So it was considered that it unfortunately she wasn't going to be the best witness that they could have got hold of. Okay, right. Let's see if that's 96 there. Yeah, there we go.
Looking backward, the OLR forced Attorney Kratz to defend his law license to avoid being required to apply for readmission to the bar and to defend himself against alleged criminal conduct. Attorney Kratz admitted that SVG counts, but disputed that he should be suspended for 6 months because of them. In time, OLR dropped 5 counts, including the alleged sexual assault count. The only new charges on the OLR prevailed were 3 counts involving tasteless sexual comments that Attorney Kratz made to 2 co-workers, and the co-worker in counts 5 and 6 acknowledged that Attorney Kratz's comments were out of character and that Attorney Kratz apologized and told her his comments were inappropriate and he should not have made them. The co-worker in count 7 also said Attorney Kratz's comment was out of character.
Well, of course, you do recall that one of the character witnesses that Kratz calls is none other at the sort of the hearing, the early hearing, is none other than Mr. Diedering.
Mm-hmm.
Remember
really?
that? Yeah, he's one of the guys that comes forward. We can get onto that later on.
The Kratz,
are you okay to carry on, by the way, dude?
I don't know. I'm getting tired, actually, but we're good for now.
We're nearly finished, to be honest.
We're fine for now. In the years following SVG's complaint, to the Kaukauna police, Attorney Kratz was forced to resign as Calumet County District Attorney. He went through a divorce. He lost his home and his car. He was sued by SVG in the United States District Court and settled the lawsuit. He filed for bankruptcy. It is unlikely that Attorney Kratz is in any position to pay $23,904.10 in court costs. These extravagant costs will pose a serious hardship for Attorney Kratz. Cannot be justified on the basis of OLR prosecution and are manifestly unfair.
Oh,
you gotta be kidding me with this, dude! You're busting out your world's tiniest violin, playing The Heart Bleeds for Kratz.
Yeah,
dude, you gotta be kidding me! Oh my god! I don't know, man. That's what I'm talking about, though. It's guys like him, that are perpetuating this in Wisconsin.
Yeah, and you've got some attorneys who I can't help thinking, they're thinking, gosh, that could be me,
Yeah, so that's crazy.
Yep.
The Kratz case underscores the need for a thorough review of the OLR practices and procedures. That's not what the Kratz case. Well, that may be one of the things, but it's probably not the most important things that it underlines.
That was 98,
Yeah. First, OLR closed the investigation against Attorney Kratz without the knowledge of the OLR director, Keith Sellen. How did that happen? Second, after reopening the investigation, OLR took 13 months to file a complaint against Attorney Kratz. What is the justification for this lengthy delay? Third, after a long investigation, OLR filed 3 sensational counts against Attorney Kratz that it later dismissed for lack of proof. Why did OLR's preliminary review committee permit these counts to be filed? Is the preliminary review committee serving its intended purpose of screening out improvident charges when it approves 98% of the OLR staff recommendations? Fourth, OLR expects Attorney Kratz to pay all the costs related to the prosecution of its improvident charges and its harsh desired level of discipline. Should a respondent attorney be expected to pay OLR's costs for charges that are not proven and a level of discipline sought but not imposed? Wow. That's to me a really shaky argument. Would love to have Travis's opinion on that particular paragraph. Fifth, OLR appears to be unwilling or unable to drop charges it is filed unless it acknowledges that the charges cannot be proved. It could likely have settled the Kratz matter much sooner if it had been able to bargain for something less than unconditional surrender. Should OLR have the authority to plea bargain with the respondents? If so, under what conditions? So now he's trying to say that there should have been able to have some quid pro quo, which is expressly forbidden by the SCR, from what I remember.
Yep.
Anyway, okay. I mean, crud. Okay, anyways, no doubt other questions could be raised about the OLR's handling of the Kratz case, but apart from this single case, there are many reasons for this court to launch a thorough, strictly objective review of the agency. If that review is undertaken, something useful may yet come out of this unfortunate tragedy.
Is it a tragedy?
Like it's somehow the OLR's fault that Kratz.
Yeah.
Oh, my gosh. I don't know what the heck this guy's trying to argue. It's mind-boggling, actually, to try to consider what he's trying to say. Oh, poor Kratz. Oh, poor. I'm sorry, dude. I'm not going to ever be able to be with you on that.
Here are the footnotes.
Okay. Because the OLR, filed its complaint prior to January 1st, 2012, all references will be to the Supreme Court rules in effect prior to January 1st of 2012. Okay.
Mm-hmm.
SCR 20:1.7 states, except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client, or there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. The other one there, 20:8.4 states, is professional misconduct for a lawyer to violate the attorney's oath. How many of these are there?
Just a few. But
Attorney's oath states, in pertinent part, the oath or affirmation to be taken to qualify for admission to the practice of law shall be in substantially the following form. I will abstain from all offensive personality and advance no fact prejudicial to the honor or reputation of a party or a witness, unless required by the justice of the cause with which I am charged. 20:8.4 states it is professional misconduct for a lawyer to harass a person on the basis of sex, race, age, creed, religion, color, national origin, disability, sexual preference, or marital status in connection with the lawyer's professional activities. Legitimate advocacy respecting the foregoing actors does not violate paragraph I. 22.28 states the license of an attorney that is revoked or suspended for misconduct for 6 months or more shall be reinstated pursuant to the procedure set forth by SCR 22.29 to 22.23 and only by the order of the Supreme Court.
So in other words, if they could have got 6 months, then he had to reapply for this reinstatement. But because he got 4 months, he doesn't have to reapply.
Right, exactly. What kind of reporter Attorney Kratz was referencing was the source of some confusion in the proceedings before the referee. In its complaint, the OLR referred to the reporter as a court reporter. 3 weeks before the disciplinary hearing, the OLR moved to amend its complaint to refer to it as a reporter as opposed to a court reporter. The referee granted the OLR's motion to amend. In his post-hearing brief, Attorney Kratz described the reporter in question as a TV reporter.
Okay, so that was just to do with that one complaint about the woman that he said had...
He described her as a TV reporter that he wouldn't have been talking about because she was neither beautiful nor had big breasts, right?
No. He said that she was beautiful, but that she wasn't the one that was well endowed.
Anyway, okay. SCR 2217 states as follows: if no appeal is filed timely, the Supreme Court shall review the referee's report, adopt, reject, or modify the referee's findings and conclusions, or remand the matter to the referee for additional findings, and determine and impose appropriate discipline. The court, on its own motion, may order the parties to file briefs in the matter. We note that the referee additionally recommended that Attorney Kratz's license to practice law in this state should be conditioned on his continued participation in a WISLAP monitoring program. We further note that in April of 2014, the WISLAP coordinator wrote to advise the court that Attorney Kratz had successfully completed a 2-year voluntary monitoring contract with WISLAP. In light of Attorney Kratz's successful completion of his WISLAP monitoring contract, we decline to order continued WISLAP monitoring.
I find, you know how they say that there are certain types of people that can even cheat a lie detector test.
Yeah,
I would never have trusted if I was sort of part of that monitoring program. How could you ever trust Kratz to be quote unquote cured of what he was doing when it goes back? Right. When it goes back to 98, 99. This is 16 years later.
Yeah.
You're
right. This is what I'm saying here.
Yeah.
It's just, the rules don't apply with certain, anyway.
Yeah.
SCR 2224, effective from July 1st of 2006, provides the court's general policy is that upon a finding of misconduct, it is appropriate to impose all costs, including the expenses of counsel, for the Office of Lawyer Regulation upon the respondent in cases involving extraordinary circumstances. The court may, in the exercise of its discretion, reduce the amount of costs imposed upon a respondent in exercising its discretion regarding the assessment of costs. The court will consider the submissions of the parties and all of the following factors: the number of counts charged, contested, and proven, the nature of the misconduct, the level of discipline sought by the parties and recommended by the referee, the respondent's cooperation with the disciplinary process, prior discipline, if any, the other relevant circumstances. We note that as an appellate court, we know only what the record contains, and we do not know precisely why the OLR dismissed the counts that it did, nor should we. This court's function is not to armchair quarterback the OLR's litigation decisions, but to review the record and determine whether the referee properly concluded that the respondent violated the ethics code by engaging in misconduct. The referee, in this case, former Oneida County Circuit Judge Robert E. Kinney, wrote the following in his report and recommendation to the court.
Can I just interject there? That is the thing that Travis was on about. I cannot find this report and recommendation of Robert E. Kinney, and I even put a message out on Reddit, and I kept getting the same answer. You'll have to. It's if it's not an unconvoluted, Brian, it's not there, and certainly I have never managed to get hold of it. But as I say, we do get little clips of what he wrote, and this is one of them.
Perhaps the most perplexing aspect of this case is the seeming incongruity between some of the respondent's professional accomplishments and the inexplicable behavior which he engaged in, which brings him before the court now. The respondent was appointed special prosecutor in the case of the State versus Stephen Avery. This was a high-profile case in the statewide media coverage. During this time period, the respondent testified he had trouble sleeping and was prescribed the drug Ambien. Shortly thereafter, people observed a change in his behavior. The respondent testified that he had been prescribed Xanax for anxiety attacks and was taking leftover Vicodin, which had been prescribed earlier after he underwent surgery. The respondent testified that he developed a dependency on Ambien and Xanax. He testified that he believes the use of these drugs diminished his inhibitions and caused his speech to be more unfiltered. Yeah, well, yeah, but that's still what's under the surface. It was just allowed to come out.
Yeah, and that was it. That was the whole of the OLR report and the sort of, if you like, the decision that Kratzky
suspended. I'm about to fall asleep.
Aye, well, there you go. There you go. That's that should done the whole lot. I mean, that's, as you say, it's quite a long.
Oh, it was good. That was good. Yeah. I mean, it was interesting too. I mean, I'm sorry I'm so tired, but
yeah.
But no, it's interesting stuff. Jeez. But it is really interesting stuff to see that the appeals court kind of given their 2 cents about what went on with the OLR. Now, I do find that one judge's opinion where he's trying to find fault with the OLR and, and like if this was all somehow the OLR's fault. No. Remember, Ken Kratz self-reported, right? That means they got involved far after all what things that Ken Kratz did anyway. So I found that odd.
I've got a couple of photographs that you might enjoy.
Oh, there we go. At least it's not a still from a jib jab. All right. I like it.
Explain.
Bunch of fine folks right there. That's all of us out there at Raleigh. A lot of the wrecking crew there. Allie there, Stacy, Angie, Fenn, Linda. Got that ugly Scott right there. Scooby, Denise, and Julie, and Tracy, and myself, and so good looking group.
I like the fact that that all the feet are in a circle, but in actual fact there's a slope there, but you're still taller than everybody else, and you're having to crouch down. You're massive.
I'm 6 foot, dude. I mean, what do you
You're
want?
more than 6 foot.
There's no way I'm not more than 6 foot, dude.
I've got another one for you I thought you might like. Where was this taken?
Amsterdam.
Oh, well done. I am impressed. This is another one I came across.
Yeah. There you go.
I don't know what was going on here. I don't know what caused this.
Oh, there you go.
Yeah.
You're like Earl. You can't keep your eyes open for pictures. I don't know if you ever watched that show. My Name is Earl, but
yeah, I have watched it a couple of times actually. It's quite good.
Every time they take a picture of him, his eyes are closed.
Yeah. And here's one of my great ancestors, Captain Harold Ramsbottom Smythe, and his good lady.
There we go. There's Captain Crunch.
that was a couple of years back at Beamish, and you get to go in and dress up in old gear.
Yeah.
So that's me and Eunice.
There you go. Right on.
Yeah. This
Captain
is another.
Crunch's grandpa. Uh-oh.
Uh-oh.
I think that T1 came up with that one, I believe.
Yeah, explain.
You want me to explain people making memes about me? T1, can you explain? You made the meme, so. But
okay. Here we go. Could you explain this one, please?
That's me and you and Mark and the other guy.
Whereabouts?
We're somewhere on the planet Earth.
Yeah, Sydney Harbour Bridge.
Southern atmosphere, or southern hemisphere. Anyway.
Yeah. And here's another one.
Yeah, it's a good looking banner. We're looking to take that thing around here real soon on the 14th.
Yep. And finally, as we are discussing Ken.
There you go. The only woman he ever loved. Hannah and her 5 sisters.
Okay. What I wanted to do very quickly was just have a look at the comments and see if there's there you go. What do you think of this one?
My voice is very soothing to listen to. Thank you, Suzanne Wallen. I appreciate that.
How much did you have to pay her? How much did you have to pay for that?
I'm very humble, so I won't let it go to my head here.
Yeah. Okay. Let's go back.
He's the prize. That's a good one Stacy did recently. I do dig that one because I like the ones that have that energy in them. I mean, I like Stacy's a soulful dude, but like that one has energy in it, and it's real, quick paced, and I think I dig that about it. But it's also clever in his lyrics, so it's funny. Love that song.
I think this is referring obviously to Kratz.
Why is he not a registered sex offender? Any normal person in Wisconsin would be over that. But look at Len Kaczynski. Look at what happened to Ken Kratz here. Start to put 2 and 2 together and realize they equal 4, which means the state is, corrupt.
Yeah.
So.
Somebody's mentioned about the book money here.
Book money will be to come up with another way to come up with another $6,000.
Because I would be interested to know if he ever did pay that $24,000. We don't know what he had to pay to settle SVG in that separate case, which of course interestingly was adjudicated by William Griesbach, and of course we've got William Griesbach was the one that dismissed the $50 million lawsuit
against
Yeah.
The Neenah Police Department, you
Yeah.
mean?
Yeah.
Right.
Yeah.
Right.
So,
Yep. The greasebacks. They're always in those greasy situations, aren't they?
I mean, I suppose, look, of course, it's going to always be the same people that crop up because it's, it's where it is.
The judges there, yeah.
Yeah.
So.
Let's see what's Claire written.
Yeah. It's not Thanksgiving for Paul.
No.
It was for me. But
I give thanks for you every day, dude.
But I'll tell you what, I had a lazy day. I woke up this morning, got on Twitter for a little while, looked around a little bit, whatever, decided I wanted to go back to bed. And I did.
Yeah.
And I slept for a few hours. I think I was about 1 o'clock when I woke back up. And I was just like, you know what? Oh, I needed some days off because I've been burning the candle at both ends and I was getting weary. That's for sure.
Okay. So just to let you know, I had a chat with Andrew Whitehead.
Yeah.
Last night, so he's all up to steam. We had a quick trial run of him getting into StreamYard, so looking forward to having a chat with him. As I say, we'll particularly focus on Brendan.
Right.
But it's just great to have a sort of a new YouTuber. He was saying that although he watched MAM quite a few times, it's always bugged him. He kept coming back to it and thinking, what on earth is going on here?
Yeah, it's just, you can't see that much, wrong and just be like, oh, yeah, you know what? It's all right. It's like, no, wait. It's not all right. Why is this happening? What's going on here? I need to understand why there's all this, why am I looking at all this evidence and going, and where's the convincing evidence? Right? Because literally the only thing they got that's convincing in any way is the blood. And the only reason that is convincing in any way is because it's blood. So it is hard to come by. But in this case, not impossible to come by.
It would be convincing if it was in all the places it should be.
It would be more convincing if it was in proper places. Yes, absolutely.
I think obviously, they if it came from the blood from the sink, it was somebody struck lucky in being able to get that blood while it was still fresh.
Yeah. Well, yes. If it was a law enforcement officer who had the right kind of water in his kit to reliquefy blood without damaging the cells, that's another possibility. Because I'm pretty sure Stephen bled probably numerous places in that garage and on that yard. There should have been probably some blood on that trailer hitch or whatever that Bobby said he cut it on.
Yes,
there should probably be some there.
Yeah,
so there's gonna be blood. Did we know there was blood in the Grand Am? So there's gonna be something laying around. There was even, I remember vaguely a report about Remaker, had like a stick in water and was trying to reliquefy some blood he found on something in the garage or something like that. I don't know. I seem to remember reading something like that a long time ago, but I don't quote me on it right now. But I do seem to remember something of that effect. So it's not beyond for me the realm of possibility that some of that blood got there from and what we also know is that Andrew Coburn was developing a friendship with Earl and was actually buzzing around the salvage yard at the time. So I mean, there's a lot about it that's just bizarre. That just anyway, yeah.
So. I mean, the other thing is we've got this Kathy, whatever her name is, who was a Wisconsin DOJ investigator. That was the previous Auto Trader magazine photographer,
right? For that,
for Teresa,
right?
And as TikTok Manitrot pointed out, why is this former Wisconsin DOJ investigator
Yeah.
Dropping her job as that to be an auto trader, she would have been higher up the food chain even than likes of the sheriff of Manitowoc
Mm-hmm. Yeah.
and the district attorney.
Right.
They're on a even higher level than those guys.
Yeah.
Yeah.
So
But no, one of the interesting things is that I think it's in Ertl's testimony. They actually go through the fact that there was blood, Steve's blood, found in quite a few places in and around the trailer, like on the doorpost where you would expect to find blood, because if he's bleeding, his hand touches that post,
yeah.
you're going to get blood there.
Right.
You've only got a tiny amount. Was it 2 mil in total? What, between 1 and 2 mil?
It's a tiny amount that they got in the RAV. Yeah, it should have from an active bleed. Should have been a lot more.
And who bleeds blood flakes?
And who bleeds flakes? You got it. I mean, who bleeds flakes?
Yeah. Did you like the that little video I did of the 80 more things?
You mean on 80 more things?
Yeah.
I only started listening to it so far.
No. The little video I did, it just about 30 second.
Oh, I don't know. I was watching a lot of things today. I watched your jib jab. I don't know. Maybe one thing I watched I didn't retain it. Maybe.
Okay. No, it's just that I found out that my favorite of the 80 more things is number 63.
Uh-huh.
Mike Holbach, grieving process. Good last days.
Yeah. That's because that's the one you suggested.
Did I?
Most likely. That's the one you would go on about.
Go on about? You mean like the control?
Wearing my favorite shirt, folks. Rest in peace, Ziggy.
I'm still waiting on my tie to arrive, but
I'm still waiting for my stuff to arrive too. I'm like, dude, I thought it was going to be here this week, but it's not.
No, it could be here.
When we go out on the 14th, I'm going to be wearing my collared shirt and Ziggy tie with one of my little lapel pins in the collar.
Oh, so you've got a Ziggy tie as well?
I ordered one. Yeah.
Good, excellent. So tell us a little bit more about this on the 14th December.
On the 14th of December, we're looking to go down to the Queen Mary in Long Beach and eat breakfast at a little place called the Promenade Cafe on the Queen Mary, actually on the ship. And then we'll hopefully get some pictures with the banner on the ship, get some pictures with the ship behind us as we're headed away from it towards downtown Long Beach. We're thinking about trying to go to the Aquarium of the Pacific. If people that wanted to come down there, wanted to show up, wanted to do that, there is a cost of $35 to get into the Aquarium of the Pacific. But it would be cool if we could get by the aquariums there with the big windows and just be doing video and have a couple of really big, like a shark or, a couple of things that are kind of big, like, or an octopus or something go by as we're there. It would be cool to have it behind. So we're thinking maybe that would be cool. But there's a lot of cool stuff to do there. And then ended up with going to one of the restaurants there in downtown Long Beach for lunch. And then from after lunch, we head over to Anaheim to downtown Disney, and there's all kinds of stuff to see there. So if you go check out the video I put up today, I actually put up a lot of images of what it looks like, down at downtown Disney and stuff, just for people to get the idea. So that's what we're looking to do. Like I said, I'll be wearing my Ziggy tie in remembrance of Ziggy, and we're going to hopefully generate some interest. I have another kind of plan that I'm playing with about us, somewhere here in Southern California, taking the banner, finding a bowling alley where we can hang up the banner and then, just bowling for like 3 or 4 hours one night on a Friday night or something in a bowling alley with the banner up while we're playing. And then obviously because the bowling, and so I figured it could be a fun thing to try as well. So we may try something like that as well.
Okay. Well, it's nearly.
But I'm really tired, so I am definitely going to have to say goodnight at this point.
It's nearly Friday.
I know it's midnight now, though, and actually really tired.
Well, you know the line by now.
I feel like my eyes are just barely open.
You have to say it's goodbye for me.
Yeah. Again, really? We're going to do this every time now? It's
Yeah.
goodbye from me, folks.
And it's goodbye from him. And if you haven't done so already,
Please hit subscribe.
yeah. Hey. Thanks, everybody. Bye for now. Cheers.
Bye, everybody.
Bye-bye.